Inshallah, I think we will commence. Inshallah, the presentation is broken up into three parts. I think to go through till 18 to 9, inshallah. Okay, so we will be looking at the Islamic law as the first part of the lecture. Thereafter, inshallah, we will be doing a general, maybe just discussion over practical application of these states. So maybe if you have your scenarios, then we can do it on the board as to what will happen to your estate. So maybe we can do that for 10 minutes. And the last 10 minutes we can just have an open Q&A. Alright, so if you're looking at this document in front of you, it's referred to as the last will and testament. It is a basic Sharia compliant will, the clauses that will ensure that when we pass away, everything we discussed last week concerning liabilities, concerning wasiya, and concerning the mirah will be given effect to. Right. If you haven't signed this will, then it means that automatically South African law finds application. And South African law, for the Interest Rate Succession Act 81 of 1987, is different to what Allah says in the Quran, as per the three verses, or primary verses I referred to last week, ayah number 11, 12, and 176 of Surah Al-Nisa. And Allah speaks about the inheritance of children, parents, spouses, and siblings as the main classes of beneficiaries. Right. So this document says here, the last will and testament, and there's a line where you can put your name and surname, an identity number, which you put down your identity number. Right. Sometimes you find people that got these wills, right? You can fill it in, but be filled in properly by a lawyer, just have to check that everything is done properly. Like, for example, the person that writes the will out can't be a beneficiary. So you can't ask your son to fill in my name and surname. I don't write that nicely. You can write the information in here, my name, surname, as well as my ID number, whatever. Right? Then the will becomes problematic because he cannot be a beneficiary and one of the writers to the will, even though he's only right to put in your information. That is in terms of the applicant law. And therefore it's important this will must be done properly. But today we will just be discussing the contents of this will. Right. So you put down the name, the surname, the identity number. Sometimes people have information on their identity document and they have different information on the normal dealings with people. Because on the identity document, the name is Muhammad. Right? That's what the parents put down on the identity document, Muhammad or whatever. Whereby, when they write the name on their book, that they own the right name Muhammad, because they said this is what I prefer. So even in the draft, your last will and testament, you can't use the word that also known as the spelling you like. It's basically the spelling on the identity document. Right? That's very important. And secondly, with regard to the identity number, this is also not the requirement in terms of the law, but why we put down the identity number is because sometimes two people have exactly the same spelling of the name and surname. For example, Muneer and Abrams, there's many of them in the Western Cape. So how do we know which one are we referring to? But the identity number is basically unique to each and every individual. Just make sure that if the will is now drafted, the correct name, surname, ID number, and also the person that is writing down that information must basically not be a beneficiary. Alright. But normally what happens when you go to the law office, they will draft everything with a computer. So if you type it with a computer, you can be a beneficiary, it's not a problem. It's only when you draft with your own handwriting, with a pen. Right? So just bear that in mind. So the second page is actually where the will starts. So you state here either as a sign, the name and surname, identity number, residing in the Western Cape, hereby declare this to be my last will. But sometimes what people do is they say, alright, I'm going to draft my own will. The will is quite basic. Like, yes, it is basic. But if you don't understand the legal consequences and concepts of drafting wills, you might have a very problematic estate when you pass away. For simple clauses. Like this first clause. Revocation clause. I hereby revoke, cancel and annul all former testamentary dispositions of whatsoever nature made by me. Now this is important. Because if you don't put this clause in your will, what will then happen is that if you have a previous will, that will would be read together with this will. Because you haven't cancelled that. So for example, in that will you gave away a car to Ahmad. Right? And in this will you give away your house to someone else, for example. Right? That car to Ahmad will still be valid because that will was signed with two witnesses. It hasn't been cancelled yet. And at the same time, if you have a previous will and you want to basically still have that person receive that benefit, the car, then that wasiyah, as we refer to it, must also be inside of the new will. Right? In the event where it is undisclosed. So if you say, I have cancelled the previous one, you are also cancelling that wasiyah that you made in favor of another individual. That's very important to note as far as these rules are concerned. Now the second clause is concerning the executor. Like now, who's the executor of the estate? Now sometimes people think the executor is the boss, right? He or she can do as she wishes. Right? Basically the executor can only do what is in this will. What happens sometimes is that the executor doesn't want to do what's in the will, the executor wants to do nothing at all. Like what do we do then? Right? Then if the executor is wasting anyone's time, then you can apply for master to have the executor removed. But the problem there is again, if you basically now when you remove the executor, you might sit in a bigger problem. Because now the deceased, or me or I, my will, I nominated my daughter to be the executor. All right, fair. But now they don't like my daughter and then they remove her as executor. Now all my beneficiaries, they must choose an executor. So it might also be that maybe the one is fighting with the other one, and this one don't like that one, and then it is delayed even further. Right, so the best thing to do is to nominate an executor that you know will be okay, the family is okay with, and also won't delay things too much. The executor doesn't actually administer the estate, the lawyers administer the estate, but the executor must sign all documentation. So the executor is nominated, whoever with the Ahmad. With the Ahmad, it goes to the lawyers says, alright, I will charge 3.5% of the value of the gross estate, that is what the law says, and he will take that. But when he drafts the papers, when he drafts a liquidation and distribution account, when he advertises the estate in the newspaper and the government, because it does all the work, right, then the final signature is not by the lawyer. The final signature is by the executor. So the executor must check whether everything is in order. If the executor isn't happy, nothing can happen. Right? Again, that is the responsibility of the executor. Sometimes you nominate one executor. Right? That is okay. Sometimes you nominate two executors. Then they work together. Sometimes you nominate one executor. Either the executor refuses, you nominate another executor. There's a number of ways of doing this. This will, however, refers to one executor. The question can also be posed: what happens if the executor dies? Right, or the executor says, I refuse. In both instances, right, the beneficiaries are still in terms of this will, because the world says who my beneficiaries are, then they must decide. And the problem is if they don't decide, then the master says, okay, I'm waiting until you decide who I will appoint an executive. You see, so that can delay things even further. Because the master wants to do what the world says, the world prefers an executor. If there's no executor, the beneficiaries must appoint an executor, they're all fighting with one another, it becomes problematic. So again, moral of the story, appoint an executor that you know will do things properly. Right. The executor doesn't have any special powers. He can only do, or she can only do what the world says. Alright, now we go to clause number 3, security. Security is also referred to as insurance. So now the person is appointed an executor, there's a car, there's a house, all of these things. But everything can happen to these assets in the estate. So what then happens is the master of the High Court might require that these things are insured. Right? And that costs money. And at the beginning, the master doesn't release money to the executor. So the executor must use his own money and insure these things. Right? Take our security. But, however, when the estate is wound up, right, then you can claim that money back. Now, sometimes what can happen is the executor will say, no, but I don't want time for this because I don't have the money also, right? Now, in order to avoid that, this clause says that the executor doesn't have to put down security. You believe that the executor that you nominated is a person that will do things properly, will look after the assets in the estate, and therefore this requirement has been exempted. Basically, you exempt the executor from furnishing security. Right, so that is a clause you can put in. Alternatively, if you don't like the clause, you can take it out, but then the estate will have to pay that burden. So from the money you left behind, they have to pay for that expense. Right, number 4. It refers to the powers of the executor. Now the executor can basically do anything that is required to be done in order to give effect to the will. Right? And you're giving the executor very wide powers. Because you don't want someone to say that with your right that the executor you don't have this power. Right? So you're giving wide powers, but again in terms of the will. If you want to give more restricted powers, you can do so, but this is just making it easier for the person that you have nominated to do what is necessary to be done, especially if there are any complications. Okay, now number 5. This is now when the actual money starts. Alright. Now we're saying that, and last week we referred to these things, the gross estate, the liability, the less estate, the wasiya, and the mirah. So the gross estate is everything that you have left behind of halal money. Right? Thereafter we said we deduct the liabilities. Right? Once you have deducted that, we have a net estate. From the net estate we deducted the wasiya, and once the wasiya has been deducted, we have the mirah that is left. And that is now what is inherited by the children and parents and spouses, for example, surviving spouses. So the first clause says, undefined. My said executor shall firstly pay all my lawful obligations and all my lawful debts contracted by me during my lifetime, including any mahar, dawah, any funeral expenses and expenses connected with the administration of my estate. So that's what last week when I said that if, for example, you owe your wife a maskari, you asked for maybe 500,000 rand, you have paid only 10,000 rand, you have 290,000 rand owing. Right? That is not an inheritance that she receives. That is a debt that is due upon her. Right? The same applies with any other debt. Could be nafaqah as well. So the husband has to nafaqah the wife because whatever reason it might be, he couldn't pay for the rent, couldn't pay for the groceries, and the wife says, okay, I'll pay for those things. Right? Also her personal expenses. And then he passes away. She can then claim those expenses as a debt against the estate. Unless, however, she says that this is a gift, no problem, you don't have to pay. Right? So therefore, I said legal certainty is important. What is happening? Right? At a time of death and divorce, that is where it becomes complicated. So these discussions must take place prior to that point in time. So it says all of those debts must be paid, as well as the funeral expenses, the janaza expenses. Right? Now, from a fiqh point of view, there's a difference between, and sometimes when a person passes away, you're asking this person to pay for the janaza expenses and that person to pay for the janaza expenses. That is not required, because it comes from the estate. The deceased has some money. Okay, we do find instances where he doesn't have any money, right? Then we don't have an estate as well, so the ummah, the jama'ah must come forth and try to assist. That is a fardu kifaya. It is a communal obligation. But if the person does have money in the bank account, he has assets in the house and so forth, there is no need to go and beg and borrow for money for the janaza, because that money must ultimately come from the estate. You can give the money to get things done, and later on you claim it back. There's nothing wrong with claiming it back because it is your right. There is not even a difference between a deceased that is a male and a female. Right? If it's a male, definitely we take it from the estate. If it is a female, then the husband must take it. But the husband must pay for it, because he pays the nafaqah. He has to maintain his wife while she's alive. And this shows that she has to maintain her even after she passes away, until she is in that hole over there. He has to pay for it. Whatever she can't afford. The Shafi madhab says that if he can't afford, then it's okay, we'll take money from the wife's estate, or from her estate. The Hanafi, however, says no, it's his responsibility. Even if he has to go big and borrow his student's money, he has to use that money to pay for the estate. And ultimately, he will still get some inheritance, then he can pay that money back again, if he made a loan. Right. So that is basically the first liability that is estate. So we see there's a gross estate, we minus the liabilities. It might be once we have deducted this, there's nothing left. Then we stop there. There's nothing left. Right. And these are the first persons who have the right to the estate. Then it says, thereafter my city executor shall endeavour to ascertain what amount, if any, is due in respect of my religious liabilities and obligations in accordance with Islamic law until the date of my death. I hereby direct such amount shall be paid as a first charge against my estate before distribution to my heirs, to such persons or institutions as my executor in his absolute discretion shall determine to be entitled thereto according to the Islamic law. Right. So here we're saying that, okay, there might be a hajj that does not perform. Because the Shafi'i madhab, you must perform a badal hajj. If you were by the means, you have money in the bank account, you were healthy, you had all of those things, but work was a bit hectic and you decided not to go. You delayed it without due reason. For example, like in that instance, the badal hajj is performed on behalf of the person that is deducted from the estate. Alright. Now the next clause, thereafter my said executor shall execute clause number 6. Now the will that you have in front of you is a basic Sharia compliant will which doesn't have a wasiyah. But normally the clause prior to number 6 would be, I hereby bequeath. I hereby bequeath, and you can say up to a maximum of 1/3 of my net estate. There's a net estate I referred to here above. That is now the gross estate minus all liabilities, religious liabilities, debt, mahar, maskar, all of those things, right? So I bequeath 1/3 of that. So if, for example, you say I bequeath my BMW, my 2010 model, in favor of whatever my neighbor, right? Then that would be a valid bequest. It's a wasiyah that would be valid. But generally, I put the clause down there on condition that the value of that car should not be more than 1/3 of my net estate. If, however, it is more than 1/3 of my net estate at the time of demise, then it must be reduced to a maximum of the 1/3 of my net estate. Because now while I'm alive, I might have many assets, and I drop this world. Then I pass away, I lost my house, I lost my car, I lost this. Then the only thing I have is that one car that I've made a wasiyah to, which is 100% of my estate, which is more than 1/3. Which means that that person is entitled only to the value divided by basically 1/3 that he can get, and the rest of it must go to my lawful heirs. Right. And even before that, if that is the only asset, and there are liabilities, that wasiyah will not be given effect to, because the liabilities, my creditors have more right over my estate than the wasiyah. But so just bear that in mind as well. And that is why the wasiyah clause is so important. It must be drafted correctly. At the same time, it does also sometimes become problematic. Because now you give, for example, in your will, I say um, I give the BMW to my brother, right, my full brother, of the same mother and same father, and keeping in mind that I have a son, a daughter, and a father, right? So that is valid because you can't give a wasiyah to someone who's inheriting in terms of the Quran already, right? But now my son and daughter pass away, my father passes away, and now my brother becomes a share beneficiary. So you can't inherit a share beneficiary in terms of the Quran and also now the the car. Right? Then it becomes problematic. Right? Then you have to update the will because now there's a conflict between what you stated in the will and what the status is in terms of basically the state of affairs. When you signed the will, there was children, but they passed away before you, they deceased you. Alright. Once that has been done, you've sorted out the wasiyah. Now clause 6 comes in. Appointment of the heirs. Now it says here, I hereby direct that the entire residue of my estate, after clause 5 claims have been deducted, as well as the wasiyah, shall be distributed to my lawful heirs to be determined at the time of my death in accordance with Islamic law of succession. Like the purposes of giving effect to this clause, my executor shall file with the Master of the High Court a certificate executed and authorized by the International Peace Council of Africa, as example of the Judicial Council SA, or by a qualified expert alim with a minimum qualification of a degree in Islamic law. So now the executor that you have nominated and it's ultimately been appointed by the Master of the High Court can then decide, do I go to IPSA, do I go to MJC, do I go to qualified alim? Whatever is best for your executor. But that institution, the qualified alim, must state that what who the beneficiaries are in terms of the Islamic law of succession. Right. So the example I gave earlier on, I give the BMW to my brother. Right. So this clause here doesn't mention who my beneficiaries are. And in my mind, at the time of me drafting the will, my actual scenario is I have 4 daughters, I have a wife, I have the mother and the father. My mother and the father lives 1/6, my wife lives 1/8, and my 4 daughters share 2/3. Right. That is what the Sharia says. But if, for example, my daughters pass away before me, and my parents pass away before me, and I made a bequest to my brother for that BMW. Right. Now, because they have passed away before me, my brother now becomes my heir in terms of the certificate executed by the MJC, qualified alim, or by IPSA. Then there's a conflict. And therefore, this will would then have to be updated in the event of that happening. Or alternatively, you have to put a clause inside there that if, however, the wasiyah beneficiary is also a beneficiary in terms of clause 6, that this bequest in favor of my brother then falls away. Right? So some clause must be drafted in that instance. Right. So that is also the main clause in this to make this rule Sharia compliant. Because we dealt with the liabilities. We stated that the executor has to find out if there's any debt owed to anyone as well as any religious liabilities for Allah. We also stated that the wasiyah, obviously that is subject to situations, but that is up to a maximum of 1/3, and it cannot be in favor of an inheriting beneficiary, like for example a son, daughter, mother, father, wife, or husband, a widower. Clause number 6 says that executor, go to the MJC, go to IPSA, go to qualified alim, get that certificate. What then happens is once you have the certificate, it's not now, it's only when the person passes away. Right, that certificate is attached to this will and submitted to the Master of the High Court. The Master of the High Court will say, alright, I see there is executor, whoever, Mr. X, alright, that's all in order. It refers to a distribution certificate. Where's the certificate? Alright, it says the MJC, alright, MJC certificate, duly stamped, alright, it all looks in order. Who are the beneficiaries? Alright, that's all in order. Right? So that is what the master will be looking for. Alright. Clause number 7. Now, sometimes what happens is you have minor beneficiaries. You have children under the age of 18. Right? The minor used to be under the age of 21 first, and we used to call them an adult if they are 21 and older. But then the law changed. They said, no, but you're no longer referring to an adult, but a major. And a major is any person over the age of 18, not 21. And also, if you're under the age of 18, you refer to as a minor. As far as inheritance is concerned, there are certain consequences. Right? If the person who's a beneficiary of the will is under the age of 18, then the money doesn't go to that person, because they're taking the person is too young. Right? So what happens is that that money that goes to the guardian's fund. It doesn't go to the estate, they don't keep it, to the government. It goes to the guardian's fund. Then the guardian fund, it keeps that money on behalf of that minor until the minor reaches the age of 18. And what also happens is any person who is looking after that minor, right, can go to the guardian's fund and maybe request what receipts, money for school fees, for clothing, groceries. But that is also sometimes a bit of a nuisance, because now you have to go every time to the master to get that money. So this is an interesting clause. This clause basically says that you are now appointing another person to keep that money on behalf of the child until the child reaches the age of 18. Right? So it could be your brother, it could be the executor as well, it could be your sister, it could be your mother, whoever you want. Right? So you make that person they call it the trustee. Alright, now there's two ways of doing it. So one way of doing it is now registering a real trust with the master of the High Court again. But that costs a lot of money, and it could take money from the estate again. Right? Alternatively, you can just make it that I give it to the person in trust. Right? That's another way of looking at it. But then again, you must trust that person, because that person can just take the money of your child and squander it and so forth. So it should be a person. So even if your executive is one person, you could nominate another person to be the trustee. Right? In the terms of the school, what you're saying is that the money is kept by the trustee until the child reaches the age of 18. Right? So you then say to the trustee that you keep the money, you use the money for whatever, and you can even invest the money in Sharia compliant investment and so forth. When the child reaches the age of 18, and whatever you have used in favor of the child, you must take a record of, must be written in a book and so forth. And when the child reaches 18, you give that book to the child, full recorded book stating that this is the amount of money that has been used, and this is the money that is left. If your father passes away, there is an interest certificate, you get this percentage of the estate, there is the money, there it is on the liquidation and distribution account, it has been transferred into this bank account. I've used over the last 4 years this amount of money for your school fees, for this, that, and the other, and this is what is left, and you give it to the child, or the major at that point in time. Right, so that is what is stated in clause number 7. It is a very helpful clause in the instance where the person passes away and they are minors. Right, and if you don't do that, the money goes to the guardian's fund. Okay, clause number 8, collation. So what collation basically means is that sometimes you have a son and daughter and they want to start a business, for example. And now you say, okay, I'll give 50,000 and start your business. Right? And now you take the 50,000 then. Now you die 2 or 3 weeks later. Now your children inherit inheritance. Right? They inherit the residue of the estate. Now the child says, no, but you got 50,000 rand before daddy died, so please, I think you must get 50,000 in this inheritance. Right? That is how South African law works. Right? If it is an inheritance. Now, Islamic law, that's a gift. Maybe you are unfair between children, whatever it might be, but it was a gift. That is different to the laws of inheritance. So what we're stating here is that the laws of collation, as applied in South African law, shall not apply to this will. So that 50,000 rand is done, as whatever the agreement was, as a gift by the father to the son or the daughter, and now in this will, whatever is left of the estate, because then what he gave away, the 50,000 rand that he gave away, that's out of his estate. It's now in the estate of the son. If it was a gift, it's gone. If it was a loan, then obviously it can still come back. Right? It's a loan. But if it was a gift, we can't say now that because you were gifted that before father died, now you must get 50,000 and less inheritance. It doesn't work that way in the Islamic law, and therefore we just state that the laws of collation shall not apply to this law. Alright, now the next clause. And these are general clauses that they have put into the law because what happened is that they found these things to be problematic. So to make life easier, is the basic Sharia compliance law. Community of property. So communal property can also be an issue at times. So if you marry someone in communal property, or you marry someone by, as you put it, by the home affairs or by court, by court, by divorce, right? So what happens is, whatever assets you have before marriage and whatever assets you have after marriage is put into one big pool. And if there is a death or divorce, then we take that big pool of both. There's only one estate, we chop it into two, right? After all liabilities have been deducted, and 50% goes to the one and 50% goes to the other, right? Whether it's Sharia compliant is another question. Now, another thing that also is a consequence to being married in that way. So if I'm married to my wife in terms of incommunity of property, what that then means is that if her father dies and leaves behind R1 million, I get half of that million. Because you married incommunity of property. Right? And if my father passes away, whatever, then she gets part of that as well. If that is my portion of the inheritance. Right? So that is a bit problematic as far as Islamic inheritance is concerned. So what we can do in this world, we're stating that if I pass away, it's my daughter's married incommunity of property. I'm stating in my will that that this money that I'm giving as inheritance, or leaving by as inheritance, it only goes to my daughter. It doesn't go to her husband. Right? And that would only happen if you put down a clause like this. So you state there, I direct that any inheritance or income accruing in terms of this will shall neither form part of any existing or future community estate. The right of accrual as referred to in the Matrimonial Property Act is hereby specially excluded from any inheritance received in terms of this will. Such inheritance shall not be subject to the right of attachment or execution by any creditor or any spouse. And so that basically helps with regard to the community of property. And also with the community of property, I think there was a few questions asked about that. It does become quite problematic, especially in the older times, I speak in that regard, where you want to buy a house, right? And they say, but we don't recognize your marriage. You have to get married by the Department of Home Affairs. Now you get married by the Department of Home Affairs, not knowing that the consequences thereof. Legal certainty is very important. I said it with regard to the loans made by the wife or the gifts made by the wife. Be certain as what's happening over there. We helping the husband out. And in the same instance, you get married, be certain as to what's happening over there. It doesn't have to become an everyday discussion, because obviously once you live a marriage like that. But the reality is just know what you are in. So that there's no problem either in divorce or ultimately death. Alright, clause number 10 says, disputes regarding the interpretation of this will. So what happens sometimes, the people, they are a will and they say, I'm going to show you now, I'm going to take you to court, like I got a good lawyer. Right? That's not the way to go with regard to these things. Maybe there are instances where you have to do that. But as far as your will is concerned, if this is now your basic Sharia compliant will, you state in the decree you don't want this matter to go to court. Right? You want, as far as this will is concerned, it must be dealt by an Islamic institution. Right? And that will be final and binding upon this estate. So here it says that you must go to the Worship Judicial Council SA or qualified expert ID with a minimum qualification with degree in Islamic law, and such a decision shall be binding upon the estate and everyone concerned. Right. The last clause is the most important clause. Some people, they sit with a will like this, they fill it in, and they look at it and they put a few question marks and stuff like that. Then they die. The problem is, they sit over there, I say, well, I say, no, the problem is you never signed it. Right, you didn't sign the will. And I've seen that. The person is alive and you exhibit and you ask questions. And I'm not in this game here. I see a person this week and next week is dead. Why? Because they know the doctor says they're very sick and that's normally when they come to me. Right? Because they know it's on their last. And it becomes problematic. Or they say, Sheikh, make this change or that change. And then again I hear the person passed away. Sometimes the people are at the hospital and they say, my man's about to pass away. She said, well, and say, you can't be making sign. I said, this guy, you can't sign it. You can't even see us. This guy, you can't take his hand and sign. You can't do any of these things. So the right thing I'm saying is, get the will signed while you are of full mind. You know exactly what you are doing. You know what is stated in the will. Get the will signed. Don't delay it too long. This is a basic Sharia compliant will. Besides this, you shouldn't have any problems. But sometimes you want to have a wasiyah, a bequest, right, in favor of this person or that person, the masjid, whatever it might be. Then you have to make a few changes. Right. Also, you might think about the trustee. You have children under the age of 18. You might think of an executor or two executors. So those are a bit more complicated cases. But if you have no will, and you basically want your will to be drafted according to Sharia, then this is the will to go. We can even execute a few wills this evening if there's a person or two that like to do so. Right? The main thing is that there should be the witnesses, as we know, is the main thing. Should not be any beneficiary. Right? And that is basically the last clause in this will. It says now clause number 11, signed by the testator or testatrix. Right? That's now you put your name and surname there. You have to act. It's in Cape Town. We're in Cape Town at the moment, or we can specify a specific location under, that is now with today's date, in the presence of the undersigned witness, all being present at the same time. Now this will must be signed by the testator, that's you and I, whose will it is, right? Each and every page. Right? We sign every page, first, sometimes people skip pages, it becomes a problem as well. Right? It has to be signed on every page. On the last page, it has to be signed at the end of the will. Right, so where clause 11 ends, that's where you start signing. There is case law where a person signed about 20 centimeters below the end of the will, and the master of the High Court said, no, we're rejecting this will. Then they had to go to the High Court to go get the will condoned, which cost about 20,000 to 30,000 rand. So that is because you never had enough time to just fix up the alignment of signing the will. And also at the end of the will, and where the secret took place, there's nothing there. You can see it's not fraud. But the Wills Act stipulates that this is how it works. Right. Another thing is that if you are a beneficiary, you can't be a witness. So what happens sometimes is, he says, look here, but I'm making my son a witness and then my daughter the witness because they know what I want. Right. But South African law, they won't accept the will because they are your beneficiaries. The witnesses must be outside of the beneficiaries of the estate. Right. And also, they ask, can the beneficiary, can my son be the executor? Yeah, it's no problem. Your wife can be the executor, your husband can be the executor. But in terms of the Wills Act, the executor is the beneficiary because the executor is getting 3.5%. Even though it doesn't go to him or her, it goes to the lawyer, but that is deemed to be a benefit. Right. So also, neither the beneficiary or the spouse of the beneficiary. Now you say, okay, like, no, it's my son, but my daughter-in-law can sign because she's not the beneficiary. But the Wills Act says that you cannot be the spouse of the beneficiary as well. So what happens at times is they sign the will, right, to see the surname. The master says, all right, I see the same surname here. Just explain to me quickly who's this beneficiary, who is the witness. He says, look here, it is this lady. Is she related to this? He says, yeah, it's the son's wife. The will is invalid. Not invalid, but basically it cannot be given effect to. We have to go to the High Court, pay the 30,000 rand to get the will condoned. You see, there's no problems over here. Right. So the best thing is, with regard to signing the will, to read properly. The witnesses is the most important part of this will. Right. And sometimes they don't sign the will. What's the problem? It's not your will. Well, you sign the will, but it's not witnessed. Also another problem. We sign the will, but the witnesses are beneficiaries. Also another problem. Right? The issue of the age of the witnesses, normally that's not a problem. We get people over the age of 16. Right? But as far as the will is concerned, it must be signed properly. Once that is done, this will is Sharia compliant. Sheikh Muneer asked, does it have to be stamped? No, there's no need for a stamp. Does it need to be registered? It doesn't have to be registered. This is the last will and testament. Right. It's registered, however, and lodged at the master's office after you pass away. And this might be your last will now, but next week or next year you find another lawyer, they say that maybe you should do this and the other, and you make a few changes. As long as it is still Sharia compliant, then that becomes your last will and testament. Alright.
You take the stipulate if it's the last.
Yeah. So what happens at times also, you find the person passes away, and 10 people come with wills. This is Ekker's executor, and comes there with a will. Now they got Ekker's executor, as a will. Other person come and execute and sometimes very sad also because each person coming with a will says that the whole estate is coming to him. That's a problem. And then he finds another will and everything comes to him. Right? And it could be read together if there was no revocation clause. But if, for example, the last will says everything comes to that person, so Sharia compliant, the master will say, you accept all the wills. And wait a bit. After waiting enough, he will inspect all of the wills. The ones that have a previous date, he will then throw away. If that last will says, I revoke all of that, he won't even look at those wills. It's only that last will that stands. Yeah. You guys, basically, I think signature in terms of the Wills Act includes an initial. It's only if you make an X that you need a commissioner of oaths to confirm that it is your identity. Yeah.
In order for this will to be legally binding, must it be notarized?
No.
Must it go to a lawyer?
So African law doesn't. Yeah, it's legally binding. No problem. It's prima facie. On the face of it, we take it that these witnesses, it's a valid law.
So it doesn't need to be changed.
No, it doesn't have to be changed. It basically only becomes a problem. Yeah, it's interesting. What happens if you marry a person later on? I don't know the answer to that one. Because you marry the witness, then I think you have to update the law. Yeah.
Well, in the case of community of property,
there's no two estates, it's only one estate. So if you, for example, make I'm just saying, you make R1 million, then you want automatically give them R500,000. If you lose R1 million, whatever, you have a car crash, then she loses half of her estate as well. So what happens is, if you have your will, right, you only can work with half of the estate. So if, for example, you made R1 million and she made 10 million, right, she inherited 10 million, for example, with no clause of exclusion. Now the whole 10 million comes into her estate, which is now your estate, right? When you pass away, you can deal with, or when she passes away, 6 million goes into her estate, and 6 million comes to you. Then you still inherit from that 6 million of hers. Yeah. Any other question?
percentage you want.
Yeah.
If you're managing community of property, you
Yeah.
can only exclude the 50%. If you're managing community of property and you don't want the road to be divided in half before it gets executed, how do you do that? Or can't you?
You have to change your community of property. What some people do actually is like, when they get the money, then they give it back. So now, for example, let's say now the estate is worth 2 million. Right? Now the husband passes away, the wife has 1 million. And she still inherits whatever the 8 is. Right? So now the choice is, but why don't we take it that we never want to work this? Right? And now she says, okay, I think so too. Then she redistributes that 1 million of her also between the children, as if it was his. Right? And therefore, if you make a community of property, I would advise you just to split it up now. Is it yours or is it his? And whatever you can do now, or you say that here, that it's registered like this now, you made a community of property, and even though the wife bought it, the wife says, okay, my husband can have it too. It's a gift from my son, even though I paid for it. Right? So it must be something that we got, so that when you do pass away, the children won't now say, they go to the Imam or Maulana and say, because this is not Sharia compliant, these are the words that you hear at that point in time. But if you have a meeting with your family, and it's clear, it's certainty, then that would avoid that problem. Alternatively, you have to change your medical regime.
Yeah. How do you deal with it?
Position, but
Yeah.
you
I mean, it's, like you said, if the 50% goes, can it not then be recorded under wasiya? In the case of community of property?
yeah, if for example, yeah, but you can't make a wasiya to your wife. She's already inheriting the 1/8. Unless all your beneficiaries consent thereto for once you pass away. And then there's the same people who have an issue now with the in-community of property. But possession, if you're looking at community of property, you have possession and ownership. There's only one estate, there's no two estates in terms of the law. The Sharia complication the issue of liabilities. Because can you enter into an agreement whereby you can, whatever liabilities my wife does, I'm also responsible for that. If she goes to bad vesting, this is all the money I'm entitled to, I'm responsible for half of that. That is where the uncertainty becomes a problem. Alright, yes? Yeah, the question is the mahar has been increased, so I paid my wife 410 for the mahar, and now I said, okay, let's both increase it now to 1 million rand. Right. So now we both agree, and we put it down in writing. Right. So if there's a divorce, I'm liable to pay the 1 million rand in terms of a contract of marriage that has been amended subsequently, and I've agreed to that increase, and yeah, she can sue me for 1 million rand. If I die, she basically puts in a claim against the state for 1 million rand as a year's dower. Yeah. And obviously the advice to have separate agreements. Right? It's just a matter of paper. Because if, for example, you got the one word and it's in the master's office, now you must go fix it, go to the master's office again, they might be stamped, it gets old. And also, you want to change things, you can't change it because the will is at the master's office, it becomes a tricky. So I would advise best to have separate wills. But you have your own will, and he has his own will. Yes?
This is a grandfather who has two sons, and they are married and they have children. The grandfather dies, but the inheritance isn't divided. Okay? And then before the inheritance actually gets divided, the one son dies. So now, because he's no longer there, then his children fall away and the one son. But what happens when he should have got it from the father? But that's supposed to be done.
If you die before the deceased, right? If you die before the deceased, like if there are 3 sons, and one son dies before the father, then that son doesn't inherit. Yeah, but now you say, I'm just saying that's the starting point, but your situation is different. Your situation is that there is now a person who passes away by 2 sons and a number of grandsons, right? So the person passes away, and before the money is given out, one of the sons passes away. The mere fact that the son was alive, his estate, his right to that estate has been determined already. Your organs and stuff like that.
Yeah, or when I'm unable to make decisions in terms of my medical conditions or something.
Okay. Yeah, in that instance, I would, within the Sharia perspective, say, okay, to give your input there, right? And also state that I would rather feel more confident by stating that the Sharia experts should just give the confirmation on it before anything takes place.
Yeah, what I'm saying more like if I'm involved in an accident
Yeah.
and I'm in a coma. I should go to a private hospital because I have the funds. But my inheritance must still know that it's a public hospital so that there's more investigation. That's involved.
As long as you're alive, and those issues are not problematic because you know where you should go to and stuff like that, that shouldn't be an issue. It's only once whether or not to put off that machine, which could be problematic, maybe a Sharia, maybe the Fatwa department should give a ruling. And I think they do a number of instances like that as well. Instead of you stating that here I'm there for 5 days and put it off, but rather leave it up to a Sharia expert to decide whether it's a Sharia we can basically put it off.
Whole life to go before they can get these things.
And that is why it's such a difficult decision to make. Because it's a gift, it's nothing to do with inheritance. It's a gift with your lifetime. So if I have a house and I decide to give the Sheikh Muneer for the rest of his life, I have the right to do it because it's my gift from my side. But myself even, I'm not entitled to use the house, even though I'm the owner. And when I pass away, that ownership of the house does pass to my beneficiaries. But the usage was given to him while I was alive, which means only when he passes away, or he forgoes that right, that they get that right to the usage. So your question is clear, and therefore it's important to think of it before making use of that. And I said the same thing I gave last week, where now you give it to your wife or to your husband, and now she is a fuss with Allah, and then use it without the house. So those are the real implications that could take place. But normally what we think in our mind is, okay, right, I'm afraid that the children will kick her out of the house, or kick me out of the house, and therefore we're looking at the best interest of our spouse. But there are also children that also might need a place to stay. So all of those things must be taken into consideration. But it is allowed in terms of the Maliki school, and it could be used where it is, where it seems to be justified. Yeah. The Maliki. So there might be, I've heard there's a minority of people in the Maliki school, but if there's a chat group here, I can give you the English fatwa that we got and you can read about it further. It's a chat group, so I'll forward the Sheikh Muneer, so you can read through it. Where the previous Mufti or embassy has spoken of the use of right, and we said that it should be, it's recommended that it be used where justified. No.
Is there any condition with regards to which religion the workers should follow?
So African law doesn't require that. But in terms of Islamic law, I think if you sign it, and it can be confirmed that it is the signature of the testator, which shouldn't be a problem. Because the wasiyat maktubatan indahu, that is written under his pillow, we can be confirmed it is his. There's an African law requirement now in the sense that the two signature must be there. But African law doesn't require the religion of the person to be the same, or male or female. They do, however, require that the witnesses must be over the age of 16. Okay. Sure.
If you inherit the grandson inherits the house from his grandfather, and he gets married, but in the meantime he didn't transfer the house onto his name, and he passed away in the meantime, who has claim of that?
Okay, so if the grandson inherits from the grandfather, means that the children were all predeceased. Yeah, so the person passed away, he had sons, but his sons passed away before him, he leaves behind his son's son, for example, right? So now the person passes away, the grandson is entitled, if there's only the grandson, there's no one else, he's entitled to the whole house.
But he didn't transfer onto his name, he passed away, so the wife is his time, he's entitled to the house now.
Yeah, so no problem, even if it hasn't been transferred as yet in Sharia law, the embassy certificate will say that the grandson inherits the estate. It takes a few months, sometimes even a year or more, to do the transfer. So once the transfer takes place, it will go into the estate late of that deceased person, and his wife and children will be there. He's not inheriting from the grandfather, he's inheriting what their husband and father was entitled to. Yeah.
So,
Instance, if the person does pass away leaving behind debt, and there's no, the responsibility remains with that person, but obviously you'll be held accountable. Therefore, if the family can settle that debt, it would be the best. As the hadith, I think I referred to last week as well, where the Prophet came into the masjid and there was a person there, the Prophet asked, are there any days that this person had any debt? And the Prophet was told, yes, he left the mosque and he said, look here, you just make sure I'm the person. And then afterwards, there was one instance where the Prophet was told, does he have any debt? He said, yes. The Prophet was about to leave. The person said, look here, but I'll stand. I'll pay this guy's debt. So please just make sure I'm the person. And the Prophet said, but if you pay the debt, is he going to be like, does he not owe you the money or does he work? It's a gift from my side. No one owes anything to anyone. The next one to the Prophet asked the person, did you pay the debt? He said, no, not yet. It's only been a few hours. And 3 waqtas has passed. On the 3rd time, the Prophet was told, yes, I paid the debt. And he said that, okay, now the punishment has been lessened. Right, so debt is not something you play around with. But yes, there are instances where it does happen. And generally the family, if they can do so, they should try to pay the debt. Because at the same time, had he had money, they would be entitled to inherit.
Is there responsibilities to them?
It's not the responsibility as far as my
So
understanding.
you can die with your debt.
No, you die with the debt and you're responsible. It's not the responsibility of the children.
Yeah, no, I just,
Yeah. So yeah, you die with the debt, and then unless however they forgive you, but if they don't, then they can claim that amount back. And therefore, that's the first claim against the state. So whatever there is, they sell the house, they sell the cars, first pay the creditors. And once they sort it out, then only we give out inheritance. But your question is, what happens if the debt is far and over and beyond what the estate is worth? Right? So they're only getting part of the whatever they try to do.
Sure.
Yeah.
What happens in an instance where the only heir that remains is walad zina?
The issue of walad zina becomes a bit problematic. And even the Indonesian fatwa also stated that if the father acknowledges paternity, okay, firstly the child was born 6 months or more after nikah, then obviously in terms of the Hanafi, some of the opinion in the Shafi also, you'd be entitled to inherit. That MJC certificate, or if that goes to the MJC, they will look at 2 things. They'll ask firstly, where's the marriage certificate? And secondly, where's the birth certificate of the eldest child? If that child was born 6 months or more, right, then obviously it could also be zina, and it was basically married immediately. But if the child was born 6 months or more after the marriage, then they will take it, basically will take it on the parent that this child was conceived in wedlock. If you say otherwise, then they would want proof. How do you know there was zina? If it's less than 6 months, then automatically they will not put that person's name down. Right, and in Sheikh said now, what happens if there's only 1 child? Right. But then it might go to the other beneficiaries as well. The MJC certificate will say, it goes to the brother of deceased, to wherever it might be. Right. Then in that instance, there's 2 possibilities. The one possibility is that to make the wasiya in favor of the child, but then it's only up to a maximum of 1/3. Right. The other possibility, I would advise in this instance, is then to make use of istilhaq, where you acknowledge paternity of the child. So say we write affidavit at the Commission of Oath, I hereby confirm that this is my child. And based on that, there is a minority opinion in I think also the Maliki Madhab and in a number of scholars have stated that in that instance, the child can inherit, which means that he would inherit everything. Right, so that must be sorted out prior to passing away. Sometimes you also find with the zina issue is that no one knows the child is out of wedlock, and then now it's time to get money out, and they look at the marriage certificate and say, but it becomes an ugly thing. It becomes a very, very ugly thing. Always that was your sister, and all of a sudden now you're saying that, okay, but you're not my sister. Why? Because of the money. You're not entitled to it. Right? It becomes a very big issue. Right? And therefore, even at the end of the process, that we feel like we must really look into these things. Right? In that situation, if everyone knows, and he always said, it's my daughter, then use that as a evidence. They can give some evidence and witnesses on the David, whatever is required, just to confirm that we feel like he said it during his lifetime. The best thing to do actually is to draft an affidavit. But now we need secondary evidence, children and stuff like that, to confirm that he was a child. But if it is from the mother, walad zina isn't a problem. The child always hears from the mother. Whether the mother married someone who didn't marry the biological father, you're always entitled to hear it from your mother. Alright. Any other question? The last question?
Yeah, I've got one here for you.
Yeah.
It says the husband and wife work together all the years. All assets is on the wife's name as formality. Can the wife leave everything to the husband after her demise? Not my wife. She.
Yeah, this formality becomes a problem. Sometimes the father also puts the one house in the one child's name, another house in the other child, and they say, don't worry, they will do the right thing. And the person passes away and says, okay, but no, I'm keeping on to this house. I don't worry, I don't need what my father says. And then one says one thing and the other one says another thing. In that case there, maybe the best thing would be, there might be tax implications, a number of implications to African law. But there must be put in writing there that you feel like that I put the house in your name, but it's not yours, and she must sign to it. Like that point in time already. Even though in South African law she is a real owner, that becomes a very messy type of a thing. The other thing is to say, Lucia, that it's your house, but you are indebted to me to this amount of money. That's the previous way. Indebted to an amount of money. But bear in mind, if there is a debt for an amount of money, the value of the property increases or decreases, but that debt remains the same. So that is another type of a risk that you are taking. Right? So to do something like that, it could be problematic. But yes, under that messy situation, just inform all the children of what happened. Maybe they need to evade taxes or whatever it might be to avoid tax. And then at that point in time, she will just say, I hereby bequeath the whole estate or whatever she owns to the husband. And then the children, whoever else who will possibly get it from the mother, would know before the time they had it around, whatever meeting around the round table, and discuss that. So that when it does happen, no one is going to fight about it. There is the last question. Yeah.
So what is the general cost of
3.5% of the gross estate. Yeah, 3.5% of the gross estate. It might, the master might even grant a bit more or even less, depending on the circumstances. So if, for example, the estate is worth 100 million, and it's only one house in Bishop's Court, then the executive can't get 3.5 million just to transfer the house to one person's name. Then the master will say, no, this is too much and we must get less. So that it's a bit, the discretion still lies with the master.
For the valuation.
Yeah.
They're saying all fees are then sanctioned by the master.
Yeah. But generally the 3.5% is accepted. 3.5% of the gross estate. Maybe we can just do one or two scenarios on the board quickly before we conclude, inshallah. I see that I'll do a few practical examples. So, or is there any time?
No.
Can we finish it maybe 2 minutes? So, is there anyone's estate we can just maybe, I don't know, to see how the estate would be wound up if the person passes away now? Anyone volunteer? Yeah, okay.
So I just own a power.
No, not the value of the estate, your beneficiaries.
Oh, beneficiary. I just have a wife and I have
Mother, father?
father.
Okay, so you have a mother. Okay, you have a father. Who else? And a widow. You pass away, it will be a widow. And
No kids.
no kids. Alright. So what happens to your estate is your
Brothers and sisters. So,
yeah, they don't need. Okay, just put down the all your brothers.
one brother, one sister.
One brother. One sister. One. But they won't inherit it. Right? So in your estate, what will happen is the mother will inherit 1/6. Your father inherits 1/6. Your widow inherits 1/8. And your father inherits the remainder. You work out the base, your base should be out of 24. 424 will go to your mother, 424 will go to your father, 324 will go to your wife, your widow, and you're looking at 16, 12, so plus 12. Right, so if your estate is worth 24,000 rand, 4,000 will go to your mother, 16,000 will go to your father, and 3,000 will go to your wife.
What happens in the case that my mother falls and I'm out?
Okay.
And I only have one.
If your mother passes away, and your father passes away before your wife, then your wife inherits 1/4. So in that instance, she will inherit 6,000 rand, and the 18,000 will go to your brothers and sisters. Right. Maybe another one?
So far, this Malang leave, right?
Or unless you get the son and then everything goes in. Anyone else like to?
Anyone?
No one. All right.
And then a wife, 2 sons and 2 daughters.
This is the lovely. Okay, I'll just make the other slide. So there is a wife.
2 sons and 2 daughters.
Okay, so in the mother and father?
Mother and father.
Okay. So there's a mother, father.
No father, sorry.
Oh, no father. So there's a mother, wife, there's a widow. And how many sons?
2 sons and 2 daughters.
2 sons, 2 daughters. Okay, so what will happen is your mother will inherit 1/6. Your widow will inherit 1/8. And the residue will be shared between your 2 sons and your 2 daughters. But your sons will inherit double share of your daughters, which basically means that last share is work it out. So it's 24 again, 4 to 24, here to 24, and 17. Right? 2, 4, 5, 6. Yeah. So basically, if you have 24,000 rand, 4,000 goes to your mother, 3,000 goes to your wife, and 17,000 is shared between your 2 sons and your 2 daughters. So we take the 17,000, we divide it by 6, and 2 of the 6 goes to each son, and 1/6 goes to each daughter of that 17,000 rand. Yeah, so if you look at that, that is why normally you ask a question of the user front. The widow gets 3 out of that 24. And that is normally where this issue comes up of what happens to the house. Yeah. There's no children. Yeah, so therefore, in the previous example, we gave the wife a quarter. Here they are children, so it's an 8.
It's an 8.
Oh, sorry, so mother, father, yeah, correct. The wife, no. Yeah, that's correct. So the wife gets a quarter. Yeah, sorry about that. Yeah. They will be sure to check the wife. That's correct, yeah. The mother 1/6, 1/4 to the widow, and the rest goes to the father. There's no way. The way to avoid the 3.5% is only if the executor foregoes that right. If the executor says I don't want it. But basically, normally it goes via the lawyer. So you know a lawyer that it's quite a lot of work to do it, right? It is reporting the estate to the master, and also drafting the LND account, speaking to if there's any creditors. So basically, they're winding up of the estate. But the executor, or if you have a son who's to be the executor and they can deal to it on their own, and they're not going to charge, that is basically what happens.
I thought you meant the lawyers are charging, not the executive. I think the executive is charging.
If the executor is the lawyer, right, they will charge.
The executive is the spouse, for example.
Yeah, they won't be able to wind up the estate. That's the problem. Therefore, I say that you can take any person that you tell us to be the executor, but that even though the person doesn't understand the law, because they must go to a lawyer anyway, and the final signature comes back to the executor.
But the 3.5 goes to the lawyer or the executive?
Once the executive goes to the lawyer will say, right, why don't they state for you in our clause of equal privacy?
So in that case, the executive won't get the lawyer gets it.
Yeah, the lawyer gets the money.
So, can I ask something? Say if I embrace Islam, like I'm married now, or is my family or non-Muslim? I've been married, my parents are alive, my wife passed away, and I passed away now. Does the vote still get distributed according to Islam?
Yeah, according to Sharia. So your non-Muslim family will be disqualified, and you have to find. And there have been instances like that, and that is where the MJC they nominated, supposed to be by to Mal, the MJC nominated maybe an organization that would use that for the benefit of the public, the Muslim public.
But you can read money to your non-Muslim brothers and parents.
The other one third.
Firstly, I think everybody, every single one of us, thought we had our affairs wound up until we heard this two lectures. I've got a face on my head. I've got to rethink everything now. I think we've all learned a lot from Sheikh. I wish to take this opportunity on behalf of the committee, the audience, both that was attending, or even the audience that's online. I wish to thank Sheikh from the bottom of our hearts for all the wisdom and that the Sheikh has shared with us, and the knowledge that Sheikh has shared with us. And we may to Allah Ta'ala grant Sheikh a long life, inshallah, and increase Sheikh in every way possible, inshallah, and grant you all that is goodness for you and your family, inshallah. And I think from a community perspective, I think this has been an eye-opener for all of us, that we need to have much more. Like Allah says, seek knowledge from the cradle to the grave. This is one of those examples that we as Muslims should take cognizance of, and we must be taught. We must always think about all of these things. If this is only one subject, can you imagine what other things there is in life that we have, our daily lives, that we need to brush up on and that we need to learn from. So once again, Sheikh, from the bottom of our shukran very much for the time, and once again to the audience and to all those that was listening online as well. I say shukran to all of you for attending and for making this the occasion that we wanted to be envisaged from the start. Inshallah, please watch the forums and the chat for further programs like this that we will be hosting shortly, inshallah. Jazakallah very much. Assalamu alaikum wa rahmatullahi wa barakatuh.
بسم الله الرحمن الرحيم. الحمد لله رب العالمين، والصلاة والسلام على أشرف المرسلين سيدنا وحبيبنا وشفيعنا ومولانا محمد وعلى آله وصحبه أجمعين. ربنا زدنا علما وارزقنا فهما. اللهم اغفر لنا ذنوبنا وذنوب والدينا ومشايخنا وجميع المسلمين أجمعين. ربنا ظلمنا أنفسنا وإن لم تغفر لنا وترحمنا لنكونن من الخاسرين. اللهم لا تدع لنا في مقامنا هذا إلا ذنبا غفرته، ولا هما إلا فرجته، ولا حاجة إلا قضيتها ويسرتها برحمتك يا أرحم الراحمين. ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار، وادخلنا الجنة مع الأبرار يا عزيز يا غفار يا رب العالمين. سبحان ربك رب العزة عما يصفون، وسلام على المرسلين، والحمد لله رب العالمين.